Well, a group of California businesses is suing Governor Gavin Newsom over the statewide lockdown. Their attorney says that the stay-at-home orders are unconstitutional and hurting businesses across the board, and argues that they should be lifted. He also is calling on a federal judge to have state and county governments pick up the tab for losses. Now, this is just one of several lawsuits being filed amid the coronavirus pandemic. So to break all of this down, we want to bring in CBSN legal contributor and former Assistant U.S. Attorney for New York's Eastern District, Keir Dougall. Really good seeing you, Keir, because it's been a long time. The lawyer representing the businesses says that the government is violating the 5th and 14th Amendments. Do they have a case?
I think they have a steep uphill climb here, and I expect that most of these claims will be dismissed. So the government has the authority to curtail rights in response to compelling public interest needs like a pandemic here. And the question is going to be how well the remedy that the government uses, how well it fits to address the problem. One of the questions, as I think we see litigation like this in the courts, one of the questions that we're going to be watching to see is how demanding the judges are in requiring that the solution to the problem be fitted to the problem itself. Can government actors, government officials, can governments use one of several reasonable approaches, or are they going to be required to use the most narrowly tailored and specific solution to a given problem? This lawsuit also faces another hurdle, which is that government officials like Governor Newsom and the other officials that are named in the suit have qualified immunity for their discretionary acts and their when they're implementing policy and making judgment calls, as long as they're not violating clearly established rights, they're going to have immunity from damages lawsuits like this.
Here, on the flip side, and it's good to see you, my friend, there's been some apprehension to some states allowing businesses to reopen despite the lack of widespread testing. So here's my legal question for you. Could a business be liable if a customer gets sick inside their location?
Vlad, it's good to see you and Anne-Marie as well, too. It's been too long. And the answer to that question is yes. The hard question, though, for lawyers addressing these issues is going to be proving causation. And it's going to be a state-by-state issue. The law of the individual states is what's going to govern. So if a customer comes into a business and then later becomes infected with coronavirus, the immediate question is going to be, was that infection caused by the trip to the business, or was it caused because of all of the other things that we do, even under social distancing and under perhaps curtailed activity that we're all observing or are being asked to observe? So there's going to be a difficult question of causation in all of these cases, given that you could potentially become infected with the coronavirus just by going outside. Businesses will be liable for what the legal term is called a tort. That's the theory, things for injury, for negligence, wrongful death. Depending on state law, businesses may be able to defend or offer defenses to lawsuits by customers for the customer's contributory negligence. They're not wearing a mask. Customer is not observing safe behaviors, social distancing in the store. There's a theory called assumption of risk under tort law, where if a business could say that the customer knew of the risk and voluntarily undertook it, that could be a potentially full or partial defense, depending on the state. But the short answer to your question, Vlad, is yes, businesses can be sued. Whether they'll be successful is another question. but it is something that all business owners are going to have to consider, even if government officials say it's okay to reopen. That's a separate question from whether or not it is wise to do so and whether or not they're creating liability for themselves by doing so.
All right, so that's a business. In Wisconsin, health officials there say that 40 people tested positive for COVID-19 after the state had in-person elections earlier this month. We already knew at that point that we were dealing with a highly contagious virus. Social distancing was being practiced all across the country. So given what Wisconsin knew about the virus, could the state be on the hook in any way because these people got sick because the state allowed this in-person election?
So that's a great question. And the short answer is it depends. It's possible that they might, but so lawsuits against governments themselves, as opposed to government officials, are treated a little bit differently. Ordinarily, you would need to file a claim, an administrative claim, with the government before you would go to court. And these rules vary state by state. If for our viewers out there, if you believe you've been injured by a state action and you're considering this, you should know that you probably will need to move very quickly. There won't be a lot of time to file a claim like this. You'll file this claim to the state agency, and they will then have an opportunity to do something with it and agree with it or deny it. And then typically what happens is then you're allowed to go to court. The issues are, again, going to be causation. So a voter, to use the example in Wisconsin, who got sick after voting, the question is going to be, well, was it the fact that they were standing online to go to the polls that caused them to be sick, or was it something else? Was it when they went to the store or when they were at work? So there's a causation question at the bottom of this. Also, there's another, similar to the qualified immunity question, the governments have a defense of sort of discretionary acts here as well, where the government action is one where they're implementing a policy, using their judgment about what should be done. That is typically a defense. So the answer here is it depends. It's a state-by-state issue. I think these claims will be difficult to make, but it is possible if a state does something, perhaps in a context other than an election or somewhere else, where they do something that's not smart, not taking steps to protect people, and do so in a way that's egregious, that a claim like this could survive.
Keir, we've got just a few minutes, less than a minute, in fact, to talk about this, but I'm really curious. It's something Anne-Marie and I have talked about. We've seen across several states people protesting stay-at-home orders. And I'm curious as to what the legalities are when it comes to stay-at-home orders. Or, for example, people who go into a playground after the city or the community has deemed that that playground is off limits because they don't want people getting sick from COVID-19, and people defy that order. You've seen people getting arrested. A lot of people complain when you see protests out there against police brutality. You know, they say people shouldn't be breaking the law, even though that is a constitutionally protected act to protest something that you believe is unjust. So what is the law when it comes to stay-at-home orders that have been implemented by state governors or even local mayors? Are you breaking the law if you go into a park that the mayor has said should be off limits because they're trying to protect people in the community?
So you, Vlad, and Anne-Marie are asking a great question, and it comes back to this issue of how narrowly tailored can a government, how narrowly tailored must a government's solution to a problem like a pandemic be? So you have First Amendment assembly rights, you have First Amendment rights to protest and to petition the government. By standing out in front of a state house. However, the government has the right to protect public health. And so the question becomes, how specific must the government's and how narrow must the government's order be to protect public health? Right now, while we don't have widespread testing and the ability to do tracing and separate people, the government's options are pretty limited, and they're sort of very broad. You have to stay away, social distancing, don't gather, those things. While we don't have the technical means to do a more narrow restriction on people, I think the government is going to have a lot of leeway to act. But as we develop the ability to be more targeted with our response to the coronavirus, the government is going to have, to pull back some of these restrictions. It's a little bit of a it depends answer, Vlad, but these are questions that I expect to be fleshed out in court in various contexts through seeking to have criminal cases dismissed, and these lawsuits against officials. We'll start to see answers to these questions.
Really, really fascinating. Keir Dougall, my friend, thank you very, very much. Good to see you. As always, providing that sound legal clarity that we so desperately need. We appreciate it.
Thank you for having me. Good to see you both.